older of the two children. May I have your names, please, for the record?
Lee Heiss, lawyer guardian ad litem.
Brittany Stover, foster care worker with the department.
Good morning, William Amadeo, P76194 for the department.
Susan Wilhelm on behalf of Caitlin Burns, Miss Burns.
Thank you. Very good. All right. So just shortly before we started, the attorneys have asked to allow for one more witness, Ms. Wilhelm.
Yes, Your Honor, I'm calling Mr. Shiloh Burns.
I'm sorry, who? What was the name of your witness?
Shiloh, would you say? Oh,
Could you spell it for me, please?
and how are you familiar with Caitlin Burns?
I've known her practically almost my whole life. I moved here about 5-6 years ago, and I came into contact with Miss Burns, a while back, and we started hanging out as friends. I know nothing, about anything that has gone on in the past. All I know is from when I moved from Colorado, her and I became good friends, as well as, family. So we pretty much adopted each other as family. I've known Zach Myers for a while, like my brother, and they pretty much, from what I've noticed, have been good parents.
Okay, I'll get to that, but let me clear the
Sorry.
record on I.
Yes.
So you're not actually her brother?
I'm known as an adopted brother.
Okay, but a real adopted brother or not?
No.
Okay, just
Yes.
familiar in that respect, but not actually a brother of either one
No,
of
ma'am.
the parents. Okay, I wanted to clear that up.
No, I'm sorry about that.
So now, was there a time when, were you in the picture and around the baby Aurora after she was born?
Not technically, no.
So you never saw Caitlin and Zach with their baby Aurora?
I saw her at one point when I came over to visit, when I dropped off a dog to her. But at that point in time, I wasn't around the whole entire time. But from what I saw at that time, they were good parents. They took care of her. They did everything a parent should. They had everything for it.
Okay, and how long was that period of time that you
That
observed
was-
the baby?
I would have to say back in 2019, ma'am.
Okay, but for how long was that time you were there in the house?
I was there probably about a week and a half.
Oh, okay, so it was a few days then?
Yes, ma'am.
Okay, and during that time, did you ever see them mishandle or be rough with that baby?
No, ma'am, not at all.
And did they attend to her every need?
Yes, ma'am, they did.
Did she cry a lot?
No, ma'am, she did not.
Was she a good baby?
Yes,
Did you view them and have the opinion that they were loving parents?
they were, ma'am.
Okay, thank
Like,
you.
most definitely.
Okay, thank you. No further questions, Your Honor.
Good morning, sir. How are you?
I'm doing well. How are you?
Good. Just a few questions. How long have you known?
I've known Zach and Caitlin since 2018. But I've recently got in contact with them in 2019 and hung out with them because I moved here from Colorado.
You're not actually blood relation, is that correct?
No, sir, I'm not.
What do you do for a living, sir?
I used to work for Taco Bell and I recently quit because of a bad shoulder.
Do you have any experience in raising children?
I do, sir. I have one of my own, but I recently had my son relinquished from me because of my ex-wife.
What do you mean by that?
She, at the time, I did not know she was red flagged through the state, and I had my son relinquished from me, which I did not know, and I was not able to take custody of my son at the time because I proceeded to marry my wife.
Okay. Are you familiar with the physical injury to the child in this case?
I was not, sir.
Okay. Are you familiar with Caitlin's financial instability in this case?
As far as I know, she was pretty stable at the time. As far as I've known her, she's been pretty consistent with working. Yeah, she's been having trouble sometimes, but not all the time. And I have helped her here and there with, cash assistance and stuff like that when I can.
Would you have any firsthand knowledge if she was on time with her rent right now or not?
She was.
Are you aware that she was $3,700 behind on her bills while having two roommates during this situation?
I have no idea, sir.
Do you have any firsthand knowledge of her mental health stability?
I can't honestly say, sir.
Do you have any firsthand knowledge if she's been seeking mental health treatment?
As far as I know, she has talked about it and she has been talking to people like counselors and whatnot that I know of. But she has been pretty well with her stability in her moods,
Would it be fair to say that you're close with this family?
fairly close.
Thank you. Nothing further.
Your youngest son was born when?
He was born day after Valentine's Day, ma'am.
In what year?
2020.
And you released your rights to him in April of 2021?
Yes, ma'am, I did.
And that was because you were experiencing homelessness at the time?
I was, ma'am.
And you were unemployed?
Yes, ma'am.
And you had been inconsistent with your parenting time?
I have.
And you were unable to meet his needs?
At the time I was, because at the time I saw better that, he needed better parenting, and where he was at, he was getting better needs than I could afford for him.
Okay, so basically you've seen these parents with this child, in the case today, one time?
A couple times.
And were there other adults there besides the two parents and child?
No, ma'am. It was just me and Caitlin, as well as my ex-wife.
So your ex-wife was also around this child?
Dropping the dog off, ma'am. That was about one time.
Okay, so did you ever know that, observe this child to have a broken bone?
No, ma'am.
Okay. So how many minutes total have you observed this family
I
with the
have
child?
to say a full 8.5 hours, because I had to see how the parents would react with the dog and how the dog would react to their child. Because I dropped off a dog to him that was part German and part Pit. But
When was that?
Huh?
When was that?
That was about 2019, ma'am. Because I recently got the dog from a friend of mine and I couldn't take care of the dog, so I asked my best friend if she would take the dog, and they wanted the dog.
So you gave the dog to Miss Myers in 2019?
Yes, ma'am.
And the child that we're here on today hadn't been born yet? Are you maybe talking about a different child of Miss Myers?
I can't recall.
Okay.
That would be the only child that I know of that was born at the time. I'm
Thank you.
thinking.
Okay, thank you. I have nothing further.
Any redirect, Ms. Wilhelm?
No, thank you, Your Honor.
All right, thank you for your testimony. May return to your seat. Would you like this witness to be excused?
Yes, please.
We gotta remember what brought us here. We have a newborn infant with broken bones. That's how this all starts. And those broken bones were unrelated to birthing. And that's been clear throughout the testimony. And respectfully to the character witness today, he doesn't have firsthand knowledge of what happened here. Firsthand knowledge we have is from our worker who testified clear and convincingly that there's a problem. We looked at MCL 712A 19B3C1. It's very clear that there's a grave concern with this parent. She was $3,700 behind on the rent despite making money to cover bills and having two roommates. The incident was tied to domestic violence. She had several no-call, no-shows, which were self-reporting in her mental health history. She's demonstrates she's capable of working and even maintaining employment for significant periods of time. So she has the financial ability to care for the child, yet we show she's unstable. She's not doing that. This child is at risk. She faced criminal charges for child abuse. She also faced criminal charges for retail fraud. It's very clear. We look at the best interest, and based on the record, it's in the best interest to terminate Ms. Burns' parental rights. Why I'm sorry for the situation she's in. If we're here to protect the child, termination is the proper move. We ask for that. Thank you.
Well, Your Honor, I would like to start by saying that in her testimony, Ms. Stover did indicate that she thought that Ms. Burns might be able to rectify the conditions coming into care in 12 months. That was the period of time that she gave. Now, is that a reasonable length of time? Would that be a reasonable likelihood that she could rectify? Well, it has been a long time in the case. We recognize that. During the case, though, she really did suffer a terrible loss when she lost Zach, the baby's father, And as we saw in the stand, she still grieves that today. It's natural. And I would put that forward as a circumstance that might toll time a little bit. But I would like to bring out a couple of things as well. And first of all, Ms. Burns has been testing negative in substance abuse since 12/27. And since THC does stay in the system a while, she was most likely negative longer than that. She herself claims that she was negative longer than that. She has also been engaging in parenting ed with recovery roads, and Your Honor, it shouldn't matter where a person does a lot of their work. Indeed, oftentimes parents choose all of their own services. It's as long as they're getting services, it should count, and that should count. She's beginning to accept responsibility. She's got a long way to go, but she's beginning to do that. We heard that on the stand. And the parenting logs that we received during the case do show that she was open to learning and that she was receptive. The testimony was that she didn't benefit, but she continued to seek help and she continued to try. I would just ask the court to consider extending her time to show that she could rectify the conditions that have brought the child into care. And Your Honor, we appreciate your time. Thank you.
We have worked with this mother for a long period of time. I would ask you to consider that there has been no benefit from services. She's been offered services since 2019. There was a year of gap between her having services and failing to benefit. But I would ask you to consider that we heard that she's not using now, from her own words, she's not allowed to or she'll go to jail. We need a period of time to see what she would do if that weren't the threat. We would need to see that she's benefited from services to the extent that she understands what THC, how that she has a THC dependency diagnosis and how she could manage life better without it. When asked why she wouldn't show for her drug screens to show us some of the positives in her case, she indicated to us that her Facebook was down, that there was a bug in her email, and then she missed one by accident. This is very late in her services to be making those kinds of excuses for not benefiting. Recently, this mother testified that her medication regimen wasn't working, so she asked for a different increase in script, and she said it was not working well enough. She was still feeling angry and depressive. I think that is indicative of where she is in her mental health treatment. She may have begun some regimen, but in the past she is not consistent with that. Her choice of friends, having left 2 weeks before and having attended this child's birth, I think we're all familiar with how unhelpful that friend has been, was present when there was a retail fraud recently. So overall, I'd like to just indicate that we are not debating whether this mother loves her child, but we all know that it takes more than love to provide for the needs of this child. There are developmental stages that she's going through. She's starting to walk. She's starting to babble. She's eating. She needs shoes and clothes and diapers and sleep time and formula and all the needs this mom is not prepared to meet. It is not credible that this the child's bone was broken from mishandling. She has a prior issue with this same physical handling of a child. What is credible is that after services, she's still having a problem with her anger. She still is not following safety plans. Now this is several years. So I would ask you to consider that this mother is not following case services. She's not accepting services, let alone benefiting from them. She has not come to the place where she trusts that people are trying to help her. She has not built a family network to the extent that she can live with someone who can help her with her parenting. She doesn't have those kind of relationships in her life to help her and support her. And what is credible is that this child suffered a broken bone in her care. and that her explanation doesn't make sense, and she has not benefited from services, and she still has not acknowledged nor benefited from services to reduce this risk of harm to the child. Let me do one more thing, Your Honor. So I have reported recently that I have visited this child face to face and observed her with her foster family. This family is stable. It has another pre-adoptive child in the home. There is a steady employment. There is an adult home 24 hours a day with the children. They have normal and usual holidays. They have a church life that the children participate in. This child does see her younger sibling regularly and has a relationship with that person. This child has not visited with her mother in many, many months, and the bond is like one of a babysitter, where maybe she'd be familiar with her mother, but there isn't a need there. She has none of her needs met with her mother. Her mother was unable to meet her needs during parenting time and to address the developmental stages that she was advancing through. So the advantages of the foster home here are, I have witnessed myself, are very disparate. The mom is working. The mom doesn't have any resources for family or for anybody she can rely on. She has this new boyfriend, but we don't know very much about that person. There's 2 adults living with her. She's still not able to meet her finances. The length of time it would take this mother to rectify conditions, the estimate was 12 months, but we've been working with her for a long time, and we don't have safe parenting during a supervised visit. That isn't enough progress to have this child wait for permanence. This mother has not complied with treatment plans. You know, we always hope that the problem with mother complying is a mental health problem, because we have resources for that and we've put those in place. It may be, though, that mom is not going to comply with the treatment plans, just like she doesn't comply with the rules at Myers. We all know we pay for our items before we leave the store. She demonstrated in the last several months she doesn't comply with the rules. That may not be mental health. That may be other parts of her personality and her disposition that cause a risk to this child. This child will need her to follow rules to get her to school, to keep her in line, to get along with school personnel. She has to follow the rules to raise a child in some sense, and she doesn't demonstrate that. The inappropriate parenting techniques are consistent for this mother, using THC during pregnancy and not being aware that the scientific evidence is still out on that, and it could be like an alcohol use during pregnancy. It could be not like that, but she wasn't aware, and she has come to be more aware. But the domestic violence, the yelling, the screaming, fighting with her girlfriend that was in and out of the house, fighting with Zach, that domestic violence matters to a child, and even an unborn child can hear the raised voice, can sense the stress hormones in the mother's body. It matters. This child does have familiarity with her younger sibling, who is also in care, and that will be continued in the foster home setting. The foster home is likely to adopt this child, is already in the adoption process for another child, and it is my estimation that they will qualify to be permanent for this child. The child doesn't have any wishes at this time because of her young age. However, it is my opinion that it is in the child's best interest to have her mother's rights terminated so that she can experience permanence and stability and have her developmentally appropriate needs met by responsible adults. Thank you. That concludes my comments.
So this is a termination trial requesting the termination of parental rights to child AM in this particular file. Her father has unfortunately passed away, so the only parent we're talking about is the mother at this time. Ms. Burns was adjudicated on this petition number 2 on April 15th of 2022, which was nearly a year ago. The removal of this child happened January 25th, 2022. The removal was due to threatened harm and physical abuse. The threatened harm was, of course, as a result of the oldest child that was a child of these two people having had a broken clavicle and the failure of these two parents to benefit from services in that case formed in part the basis for the request for removal of this child, who at the time she was removed also had a broken clavicle. That's part of what will be under quite serious consideration of the court today, but I wanted to just review that to talk about putting things in context. When the court looks at termination of parental rights, the termination of parental rights hearing is divided into two phases. The first is to determine whether there is clear and convincing evidence to support that statutory grounds for termination of parental rights has been established, and also the second phase is to determine if it is in the child's best interest to terminate parental rights, which is, of course, why Ms. Heiss spent so much time talking with us about the best interest factors, which I appreciate, as well as the testimony of our caseworker. The statutes that the court's been asked to consider include MCL 712A.19B3CI, whether or not Caitlin Burns was a respondent in a proceeding brought under this chapter. 182 or more days have elapsed since the issuance of the initial disposition order, and the court, by clear and convincing evidence, finds the conditions that led to the adjudication continue to exist, and there is no reasonable likelihood that the conditions will be rectified within a reasonable time considering the child's age. Second is subsection G, whether or not Caitlin Burns, although in the court's discretion was financially able to do so, has failed to provide proper care or custody for the child, and whether there is a reasonable expectation that the parent would be able to provide proper care and custody within a reasonable time considering the child's age. And finally, under subsection J, whether or not there is a reasonable likelihood based on the conduct or capacity of Caitlin Burns that AM would be harmed if she were to be returned to the parental home. Under subsection CI, we go back to revisiting some of the things that brought this child into care, which were, of course, the history of injury to an older sibling and some services that were undertaken by the parents that were unfortunately did not prevent the subsequent injury to the second child, and therefore clearly established that there were no benefit from services in that in that petition for that child. And so that was under review at the time this child was removed, which of course was also an issue was that injury to this particular child. On April 28th, 2022, a dispositional order was entered as it relates to Caitlin Burns. She was a respondent parent that was named in the initial petition here, petition 2. And there have been a number of review hearings to determine whether or not Caitlin has benefited from services and abided by her case services plan to hopefully establish progress to the extent that she's relieved the risk of harm that brought the child into care. Was very shortly after the jurisdiction of the court was established, a psychological evaluation with Dr. Haugen on May 16th, 2022, which was, of course, provided to the court. Dr. Haugen reported that Ms. Burns would need to participate in therapy focusing on abuse and neglect, past trauma, and the impact it has on her parenting skills and her cannabis use disorder. He recommended she participate and show benefit from parent training and intervention. As I review the record, which I'm obligated to take judicial notice of since the date of disposition, it would appear that she was offered services. I do want to, before I do that, I do want to review this too. There was evidence on the left clavicle fracture of this child at 11 days old. There were records that were introduced at the initial disposition. On January 27th, 2022, the University of Michigan Child Protection Team clinic examination did find that fracture and determined that it was not a result of an accident. The child was born positive for THC and demonstrated symptoms of withdrawal at the time of birth, including tremors. At the time the child was brought into care, there was neither parent had reliable housing or employment. The mother was engaged in some MSU parenting classes, it appeared at that time, but was having trouble with transportation and missing visits. That was a pattern that continued to be demonstrated by both parents. It was intermittent attendance at visits at best. There was quite a few missed visits. And then, of course, had to do with the challenges that the parents continued to face around employment and transportation. At the base of those issues, of course, were some of the things that were identified by Dr. Haugen. She needed to focus on parenting skills, her cannabis use disorder, understanding abuse and neglect, and how it would affect her parenting and how it had affected her parenting up to this point. She was denied the opportunity to breastfeed until she was able to purge THC from her system, which never happened in this case up until she was put on probation for a deferred charge of child abuse associated with the injury of this child, and she was threatened with jail. Since that point has been the only period of time in this case that she's been able to demonstrate abstinence from marijuana, despite the fact that that affected her child significantly at the time of birth. Prelim on 12/12, there was some testimony about very recent psychiatric care that Ms. Caitlin was undertaking, including inpatient, which is consistent also with Dr. Haugen's findings. She testified that she had been diagnosed at that point with some kind of explosive or regular bipolar disorder. It wasn't clear. She's got a long history of mental health issues. She was supposed to be going to counseling and went away for probation at that time, focused on anger management and parenting. She had, even though her fiance had just very recently passed away, she had already had a new relationship at that period of time. And at the time she was adjudicated even, she was denying that there was any child abuse as a result of her actions, blaming the injury on a handling problem, which we heard again very consistently over the course of the different reviews here, that it was simply a handling problem that she wasn't aware of, and that no one had taught her how to hold a child in a way that would prevent injury, which is simply incredible. She's had a number of opportunities to engage in education, including around the first child that was injured. There were additional classes offered through here. As of 12/21/22, at that particular review, in attempting to engage in therapeutic services as recommended, we received into evidence an email from the counselor, Michelle Palmer, denying that she would be willing to offer any therapy or parenting classes for Caitlin. She said, quote, "Caitlin has not changed. She lies constantly, has a million excuses, and has no desire to follow through with any type of program or therapy." Quote. That was very strong language from Ms. Palmer, who has since re-engaged, but it was very clear that the re-engagement was not inclusive of any services for abuse and neglect. And I think that continues to be reflective of the very strong reservations she had over a year ago in working with Caitlin. We had inconsistent testimony from Caitlin over the course of the period of time that she was subject to court reviews. For example, the Family Medical Center appointment log back in December contradicted her testimony about a 9-month wait list. In fact, that she had been actively missing appointments. She continued to test positive for THC. And of course, including before the adjudication and all the way through the course of reviews, she continued to pick up retail fraud, criminal charges, failure to report property damage accidents, and the second-degree child abuse deferral as a result of the injuries to this child, regardless of the fact that she continued to deny that was as a result of her direct actions. At the dispositional review on February 13th, 2023, there was a lot of indications in the biopsychosocial assessment that Ms. Caitlin continued to struggle in the areas of substance and mental health, that again, she denied any kind of responsibility for the injury that brought this child into care in part, which is very recent. She took a questionnaire through Family Medical Center, and similar to some of the struggles that were found when she was attempting to secure services for substance abuse through CMH, the way she answered that questionnaire indicated to the counselors at that time that she had no need for substance abuse disorder treatment, even though clearly her use of substances, marijuana, did affect her child, who went through withdrawals at the time of her birth. And education around that would be imperative to prevent her from making that mistake again, and of course, imperative to allow her to move forward in active progress on her own trauma and parenting needs. We heard on February 2nd, the FTM notes reflected and were brought into evidence that there was still housing needs, that she had not provided the docs to Housing Help of Lenawee at that particular time, that she could have been involved with Family Medical Center for counseling, but that she decided to wait for Parkside, even though she understood this petition has been filed and pending for some time, and there's no reason to think that she would not have understood that her engagement in services was absolutely imperative in order to demonstrate to the court that she was willing to undertake education and effort around that. She was terminated from Parent Education Services with Orchards Children's Services back in June 8th of 2022 due to recent child abuse criminal charges. And as recently as last September, again, she was arrested for retail fraud. So around the issues of housing and substance abuse and engagement in services, it can be said that Ms. Burns recently has re-engaged in counseling, which I've already addressed, was very clearly cut away from engagement on services that she needed and around the issues identified by Dr. Haugen. And of course, she has been testing negative for substances, but again, that is very clearly as a result of her probationary terms upstairs. And when our caseworker testified that she would need at least 12 months, that was because we anticipate Ms. Burns to be on probation for at least 12 months. So we would need to see a demonstration of her abstinence and engagement in services in a very productive way, showing benefit for even longer than that period of time. And given the fact that she was unable to benefit from services under the first petition, and that she's had nearly a year from the initial disposition, but more than a year from the initial filing of the petition to identifying these issues to work on services, it's clearly been more than 182 days at minimum that she had to demonstrate whether or not she was able to benefit from services around housing, substance abuse, and parenting skills to prevent physical injury to a child. And I do think that there's clear evidence here that she did not benefit in a way that would allow us to, number one, return the child to her home. There's clearly a reasonable likelihood that any child would be injured in the care of Ms. Caitlin Burns. 2 children have already been injured in her care, and she's not benefited from services. She's been disingenuous about engagement in services and has been intermittent at best. So I do find that there's clear and convincing evidence that her parenting skills have not improved to the extent that the conditions that led to the initial adjudication were remedied. I want to congratulate her on the term of abstinence, but again, I don't think that there's a reasonable likelihood that we could expect her to continue her abstinence within a reasonable time, allowing her to show benefit considering this child's age. She's very young. We've been born January of 2022. We would need at least 12 months, and then I would say at least 6 months, another 182 days after she's completed probation, in order for her to really demonstrate that she had rectified even the conditions around housing, employment, and substance abuse, let alone the issues of parenting education. She's been unable to demonstrate progress in any reasonable period of time, and I find that there's no reasonable likelihood that those conditions would be rectified within a reasonable time considering this child's age. I also find it very credible and clear and convincing evidence in the argument made by Mr. Amadeo that Ms. Burns does have the financial ability to provide proper care or custody for this child, and that she has not demonstrated that. She has not provided support for this child. She's not been able to provide even during visitation, as was noticed by Ms. Heiss. And as a result of her extended opportunity to demonstrate that since the initial disposition in this file, and of course, the prior opportunity in petition 1, that there is no reasonable expectation that she would be able to provide proper care and custody within a reasonable time considering this child's young age. And of course, for the same reasons articulated under subsection CI, I find under subsection J that there is a reasonable likelihood based on the conduct or capacity for Caitlin Burns that AM would be harmed if she were to be returned to her parental home. As it relates to the best interest factors, at the time of the filing of the petition, this child had been in care for 10 months from a very young age as a result of a very serious injury at infancy, and of course those withdrawals from THC. She was placed in a licensed foster home that was willing and able to provide permanence, continues to be willing and able to provide permanence, and has demonstrated that they are able to meet this child's needs. Have her evaluated for both her injuries and the detrimental use of THC during pregnancy, and guide the child through those significant challenges. They are, of course, as a result of that, very well bonded to this child. They've met her needs on a daily basis and on an extraordinary basis, making sure that she's been able to heal from those challenges. Their parenting abilities at home are, as Ms. Heiss pointed out, superior to Ms. Burns's abilities, despite many opportunities to demonstrate engagement in services to improve her parenting education. She's not been able to do that in any beneficial way. And of course, we had that very negative review around her efforts by her counselor rather early on a stage of things, having had the opportunity to work with this parent in a prior setting. The court does place quite a bit of stock in that particular expert's opinion of Ms. Burns's opportunity to take advantage of parenting education. And of course, we would find her efforts disingenuous at best and certainly without benefit. She's not been compliant with the case service plan, as was previously noted, in many significant areas, including failing to complete the services necessary to overcome the challenges identified in the psychological, which obviously are very necessary given that without those benefits, a child could again be seriously hurt in her care. Visitation was intermittent at best. She was not able to meet the child's needs even during short-term visitation, and was unable to make visitations. So for all those reasons, as well as the need for permanency and stability in this case, it is the opinion of the court that there has been a preponderance of the evidence, backed by, of course, the opinion of our guardian ad litem and caseworker, that this child, it is in her best interest that the parental rights of Ms. Caitlin Burns be terminated. So there is a preponderance of the evidence as it relates to the best interest factors as well. There will be no further efforts towards reunification or to prevent removal. The child will be committed to the Department of Health and Human Services for purposes of adoption or other similar placement, having confirmation from her foster care home that they wish to adopt her. We will be continuing to monitor progress on that adoption as the case moves forward. We have the matter of petition 3. I'd like to offer March 14th at 9 a.m. to the attorneys to see if we couldn't have a hearing on petition 3 for purposes of adjudication and disposition on March 14th at 9.
I'm fine that day, thank you.
I'm fine, thank you.
So for now, let's just go with what my secretary has suggested. She's usually ahead of us on these things. March 14th at 9 a.m.
Thank you, Judge.
Burns has the right to appeal. We'll be forwarding her all of that information, including how to request an attorney if she can't afford one. Court would be happy to appoint a Court of Appeals attorney and furnish that person with the transcript for purposes of advocating for her on that appeal. And all of that will be served by email and regular mail, in addition to the order and a written copy of her appeal rights. Unless there's any questions, that's all.